discuss the fact that the draft constitution is to be reintroduced back to Parliament. On the 14th of this month, we received a press release from the Ministry of Justice through the Ministry of Information announcing that government has regazetted the draft constitution. But of course, there have been some adjustments. Today, I am joined by the Minister of Information, Dr. Ismaila Ceesay, who has some clarifications to make on government's position on the revised draft constitution. But of course, we're aware there have been some controversial issues that people have been discussing so long as their opinion is concerned on government's decision to make some adjustments on the draft constitution. So this is an opportunity for the Ministry of Information, of course, speaking on behalf of government, to clarify certain issues that have sparked a debate, public debate, expressing their concern on the revised draft constitution. Honorable Minister, thank you very much for joining us on this program.
Thank you very much, Mr. Chair. Thank you for having me.
The fact that the draft constitution was rejected by Parliament in 2020 signaled that perhaps there must have been something wrong and there was no political consensus. In your view, what was politically wrong when it comes to the 2020 draft constitution?
Well, I think two things. One was that the CRC, we have to commend them for doing a very, very good job, a very comprehensive work, but I think they made two mistakes along the way. And I think also other political stakeholders also made some mistakes. The CRC, failed to pay attention to the concerns of the broader spectrum of the stakeholders. And I'll give you an example of that. When the cabinet made a position paper that the retroactive clause was problematic for them, the CRC did not pay attention, they still maintained it. But when Lawyer Dabo, the leader of the UDP, made a statement that the clause that bars anybody who was convicted from running for president, and that if that clause is maintained from the original draft of the Constitution, the 2020 draft, that they would make sure they fight the Constitution. But I think the CRC paid attention to that and removed that and rewarded it to allow convicted people to run for office. So, but they failed to pay attention to the concerns raised by cabinet. That is one. Now, the second one was that I think the CRC also were kind of haunted by Jammeh's ghost, to the extent that the never again mantra, even the world supported it, but they have to understand that Gambia is a very strong presidential system. Now, you cannot bring a system where you kind of take all powers away from the presidency and give it to the National Assembly and other organs of the state, thereby creating a lame duck ceremonial president, which could cause a constitutional crisis. So at some point we realized that the 2020 draft had serious fundamental flaws, and that most of the powers were taken away from the presidency in a very strong presidential system, which could cause a problem along the a logjam along the way. And these powers were given to the National Assembly. So effectively they created a president with no powers. And this was very problematic, and this could cause us a problem along the way. I understand the CRC's thinking at that time, coming from dictatorship, coming from the way Jammeh was abusing powers. They thought that the next president would not be having such powers, so they took most of the powers away from them, and this was problematic. So these are the two things that were problematic in the Constitution, particularly the fact that the retroactive clause was made to stay, which nowhere in the world is basic principles that laws start to take effect from the time they are implemented and not backdated. So I think this was a problem for that particular draft. But also, we also have to. So what cabinet has done now is to refine the document after a series of consultations, listening to a lot of stakeholders, refine it, and to ensure that the problematic clauses are rectified, and to ensure that we align the Constitution not only with our democratic principles, but also our democratic aspirations as a people, not for only today's generation, but also for the next generation. Remember, we don't want to change constitutions every 5, 10 years, 15 years, 20 years, whenever there's a new president. We want this constitution to stay for the next 200-300 years. Therefore, when we build this constitution, it must take into account not only the aspirations of today's generation, but also the aspirations of future generations.
I understand that the executive had some concerns regarding the 2020 draft constitution. But of course, it was also, even though it had some concerns, perhaps there were also some comments that the executive made to the draft, but it had to go to Parliament, pass the first reading to the second reading. But still, the legislature had the opportunity to do a legislative scrutiny on that document, where at the committee stage, they could have had the chance to maybe adjust on these issues that you have highlighted. At Parliament, both sides of the political divide are there. Why couldn't that happen?
But remember, the threshold is very high when it comes to voting for the repeal of the 1997 Constitution, 75%. They could not get consensus, political consensus in Parliament. That is why it was kicked out. But remember also, there were other opportunities for us to get this draft passed. Now, when there was a stakeholders forum among the political parties, 10 sticking points were identified. All these 10, there was convergence in almost all of them, except one, the retroactive clause. And we went to Abuja. I was there representing the Citizens Alliance Party at that time. We were hosted by Goodluck Jonathan to discuss. Political party heads were there to discuss the constitution. We all agreed on almost the 10 sticking points, except the retroactive clause. And all of us in the room agreed to at least negotiate and accept the retroactive clause to be removed in exchange for us to have a constitution, a kind of a bargain. The UDP was the only party in that room that disagreed. So effectively, the reason why we don't have a constitution today is because of the UDP and its leadership. Because at some point after it was thrown out of Parliament, we agreed on almost all the issues except the UDP. So today, and again, I think that even if it doesn't pass now in Parliament again, it is going to be the same UDP, because they are saying that even if a comma is removed from the CRC draft, they would still vote it out, and that they want the original draft to come back as it is, which is not possible.
Would that not be the fact that either side of the political divide is not willing to compromise if it fails?
No, but the NPP was willing to compromise in Abuja. They were willing to compromise. They were willing to give and take. All of us were willing to give and take. And the only sticking point was the retroactive clause. Had the UDP agreed at that particular meeting, would have passed the constitution after that. But unfortunately, that did not happen.
Okay. Now we move to the next question. The fact that government has announced the regazetting, that is, it just mentioned the phrase, refined the constitution and now published it in the Gazette, meaning it is to be introduced to Parliament some months to come. What process did it take government to arrive at that stage? What did government do in order to arrive at that stage when it had to refine and regazette the constitution?
Well, immediately after the constitution was rejected in Parliament, government gave the Ministry of Justice the go-ahead to start consultations to take it back to Parliament with rectifications, obviously, making sure that the contentious points were there was a convergence of agreement. Series of consultations were done. One was the first phase, two phases particularly. First phase was in December 2021 to 2020, March 2022. This one was sponsored by the UK Foreign and Commonwealth Office. It was chaired by Goodluck Jonathan. Party leaders went to Abuja. We had discussions. Some issues were raised, some contentious issues were raised. There was convergence in some issues. The second phase was sponsored by the Netherlands Ministry of Foreign Affairs, headed by Dr. Eben Chambers. There was a high-level meeting among political parties. Civil society were engaged. So all these consultations revealed some issues that we thought, or that were presented to Cabinet to discuss. Cabinet reviewed the document again, like I said, refined it to ensure that some of the problematic clauses are rectified in accordance with the principles of justice and the principles of the rule of law, and also to ensure that the constitution that we are going to bring is aligned with our democratic principles and our democratic values, but also with the aspirations of today's generation, but also the future generation. So it was a very transparent process. That is why when I see people saying that the process was not transparent and consultative, I wonder what they mean by transparent, because this was very consultative. There are two series of very comprehensive, rigorous consultative periods. There was also a very transparent process, but also the next process was very transparent. What did the law say? It should be gazetted. It's called public gazette. The Cabinet gazetted it. Now the government has gazetted it for the public to go and scrutinize it. And whenever they see anything that they think is not right or they don't agree with, they can now consult their lawmakers when it goes to parliament. So this process has taken, so basically there are 3 stages of the process. One was the consultative period. 2 was cabinet reviewing the document to refine it to ensure it is aligned with democratic principles, but also with aspirations of the Gambian people. The 3rd one is the public gazetting. So the public can now go and see what has been changed and whether they agree with it or not. And if they don't agree with it, they can now engage their lawmakers, because from gazetting it goes to the National Assembly. So National Assembly also will have to sit on the document again. So it's not like it's a final document. I think therefore Gambians should give the document a chance to follow its due course. It is gazetted. Let the public go and engage the document, read it, highlight some issues that they think they agree or disagree with. It goes to Parliament, and Parliament does the job, and it goes for a referendum eventually.
Public opinion, but of course the opinion or the reaction of some political parties, one might say, suggests that they are shocked and surprised with the adjustments the executive has made. Is it not the case that perhaps what came out of the consultations was not reflected in what has been refined?
They were reflected. I mean, cabinet will not just go and change clauses not based on what has been based on consultations and not based on the public's interest. Cabinet has a role to play, and here cabinet had the authority and the legitimacy to refine the document, because the cabinet has executive power. Now, whether cabinet has the legitimacy or not, people can have the legal question, but what I understand is cabinet has the legal authority to refine the constitution as it is, because the original draft really wasn't there are some fundamental flaws. It wouldn't make sense to take that original draft back to parliament again. That will defeat the purpose. So therefore, it was refined, and like I said, in a very transparent, consultative manner, and like I said, to reflect not only the aspirations of the Gambian people today and tomorrow, but also to align with the Gambia's democratic principles and governance system. Like I said, we have a very strong presidential system, and that is very important for people to understand. You cannot have a presidential system and bring a constitution that reflects more like a parliamentary system. It causes a problem along the way, and we have to understand that the constitution has to reflect our governance and our political system. So that is very important for us to take note.
Yeah, to what extent does the executive, here the balancing act has to come in play, the interests of the executive to introduce us into the Third Republic, and also the interests of some other groups that emerged during the consultation process. How do you balance this? Because we've heard from one of the main political parties saying if anything is removed from the draft constitution, it has been refined by the executive, then they wouldn't vote for it. To what extent would you, do a balancing act? You want to usher us into the Third Republic with a new constitution, but also maybe to capture, the interests of some other groups and some members of the public.
Yeah, but that is why we gazetted it, for the public to now engage the document and highlight some of the issues that they either agree or disagree with, and engage their parliamentarians. Like it said, it's a process, and the process won't end until after a referendum sometime next year. So people have to understand that cabinet amendments are not an end in itself. It's not like document now is complete and dusted and is going to pass into law.
So it's basically the position of the executive. Now it will be introduced to Parliament,
it is
lawmakers, and therefore...
It is gazetted now for the public to access the document and see the changes that has been done and see the constitution. And now engage their parliamentarians, and it goes to Parliament. And Parliament will also do its bit. Cabinet can further do some amendments as well, depending on how they see things. So obviously, and then it goes to a referendum, and the public will eventually decide. So this process, people have to allow the process to take its course. I think it's unfortunate for a particular political party just to say that if you don't bring the original draft, we'll reject it outright. That is not doing justice to anybody. It's not doing justice to the country, and not doing justice for the constitution, and not doing justice to our endeavor to consolidate our democracy and bring a new constitution. The President, His Excellency, and our has promised to bring the constitution back, and he's done that. He's a man who fulfills his promises.
And even set a timeline.
Exactly.
Timeline by December.
Exactly.
Which is,
it might be tight.
Very
it might
close.
be tight. Yes. Because these things you can anticipate, but again, some things are beyond your control. But now, what the government has promised to do, and that whilst they've done it, they've reviewed it. They've done some few amendments based on consultations prior, including political parties and civil society. They've gazetted it for the public to engage with the document. It goes to Parliament, and now Parliament do their job. When Parliament is done, it's for the public to now decide whether on that particular constitution in a referendum or not.
One of the things that has raised public eyebrow, some members of the public, of course, and some other political groups, relates to freedom of assembly, potentially to demonstrate and exercise, as part of their right. When it comes to the arresting, of people, and also arresting and detention of people, the 2020 draft constitution stated 48 hours as a limited number of time that a person could be in detention, without which he or she should be released, or before the expiration of the 48 hours should be brought before the court of law and charged. That has been extended in the revised version of the draft constitution. What is the...
It is not extended, it is just reset. In the 1997 constitution, it is 72 hours. Why change in the first place? Whereas in the 1997 constitution, it is 72 hours. Why change it to 48 hours? I mean, these are operational policing procedures.
Why is that a problem? Why is the 48 hours a problem for the executive?
Because if you engage the police themselves, they are struggling with the 72 hours. So what happens is that you have criminals back in the street within 48 hours. 48 hours, sometimes it's difficult for you to gather the evidence you need to take someone before a competent judge for them to be remanded. 48 hours can be too small. So why change it to 48 hours in the first place? Initially it was 72 hours, which was even a problem for the police when it comes to operational issues. Why bring it down to 48 hours in the first place? What was the rationale for it? What was the justification to reduce it from 72 hours to 48 hours? As far as I know, as far as my engagement with law enforcement is concerned, the police have been struggling with the 72 hours. It can be too short for you to gather evidence against an alleged criminal or alleged culprit to put them before a court of law for remand. So what happens is that within 48 hours, you don't have enough evidence. You have to release that person back to go back to the society and commit more crime. Therefore, I think that has to be a decision that has to be really revisited. 48 hours is too small. Yeah. So, I mean, why change it in the first place? That should be my question. Why change it in the first place? 72 hours has been working fine.
So one can conclude that the decision of Cabinet to revise the 48 to 72 hours in accordance with the draft constitution was informed by maybe, was inspired by what you received as part of the consultation from the security sector.
I'm not speaking for, I will not be justifying for Cabinet here. I'm speaking here as what I see things. I mean, some of these are technically legal, and I think the Minister of Justice now is coming with a press conference soon. He'll go into those details. What I'm saying, broadly speaking, at a general level, is that why change it from 70 to 48 hours in the first place? If the 1990 constitution that has been working for many years is 72 hours, and the police are even saying that that's even tight, why bring it to 48 hours, causing more problems?
We move on now because we have more areas to touch on. Viewers, for those of you who are just following us right now, you are watching the Gambia Radio and Television Services, and with me in the studios today is Dr. Ismaila Ceesay, the Minister of Information, and we are discussing the constitutional building process of the country. Some of you are aware that the draft constitution has been regazetted by government, and some months to come will be introduced in Parliament. But of course, when it was regazetted, people have had the access to review the document, but they also have raised some concerns, sparking debate. Now we have the Information Minister to clarify on some of these talking points, so long as the public opinion is concerned. Now we move on. Chapter 5 of the draft Constitution, 2020 draft Constitution. Here we have two draft Constitution here, the draft and the redrafted Constitution. Chapter 5, 2020 draft Constitution provided guidance on good governance, and good governance, defining, the principles of leadership and all of that. But it has been removed. It has been totally deleted from the draft Constitution. It's not in the refined one. What led to this decision by Cabinet, and how will the principles of good governance be addressed in this new redrafted Constitution?
Well, you see, Constitution building is a very rare enterprise. The Constitution is not supposed to be very detailed, legislatively speaking. The Constitution always, anywhere in the world, just lays the framework for governance. Now, you don't put issues of integrity in public office in a constitution. There's nowhere in the world, there is no serious constitution in the world, in the biggest democracies, in the most entrenched democracies, that deals with issues of integrity in public office in a constitution.
But good governance is not integrity.
No, this chapter is integrity.
Integrity.
It's integrity in public office. And issues of integrity are subjective. You cannot get any Supreme Court in the world to interpret issues of integrity. These things should be left for subsidiary legislation, let's say in the GOs or in the public service instruments, but not in a constitution. It's going to cause more problems than it's going to solve problems. So therefore, I think that was the part of the reason. Like I said, the Minister of Justice will go into detail as to cabinet decisions after that. I don't want to preempt it. But broadly speaking, my understanding is that anybody who understands constitution building process, you know that issues of integrity, issues that are subjective in nature, you don't put them in a constitution, but it causes problems. It's very difficult for any Supreme Court to interpret when there's an issue. So for me, I think it was a very wise decision for the government, for the cabinet to remove that entire chapter, because it doesn't make sense. It doesn't fit in a constitution.
Now we move on. We will look at the freedom of assembly, of course, which I hinted earlier on. In the 2020 draft constitution, we've seen that it said the freedom of assembly shall be exercised subject to the law of the Gambia insofar as that law imposes reasonable restriction on the exercise of the rights and freedoms thereby conferred, which are necessary in a democratic society and are required in the interest of sovereignty and integrity of the Gambia, national security, public order, decency, or morality, or in relation to contempt. This is what the redrafted constitution is saying. But when you look at in the CRC draft, it guaranteed, the freedom of movement, but not setting, some kind of limitations. How would you explain this to the public as part of government, cabinet
freedom of movement or assembly?
Freedom of assembly.
Assembly. I mean,
freedom
obviously, listen, that was another fundamental flaw by the. You cannot give freedom of assembly unrestricted in a democratic society, which has a fragile democracy. Remember, it's a new democracy, and even in strong entrenched democracies, people still need permit to really assemble, especially to demonstrate. Now, the purpose of the permit is not to restrict people from assembly, it's to protect them. Because obviously, the right you have to protest for a particular cause is the right other group has to counter-protest against a particular cause. And for the police to be able to do an assessment of the security situation at a particular point in time and protect the public's interest in terms of property and persons, the police must be able to get prior notice that a particular group or groups want to do a peaceful protest or want to assemble. So they can do the necessary assessment and give you necessary security you need to protect life and property. So for me, I think, yes, people have a freedom. They have a freedom to assemble, but at the same time, this freedom of assembly must not be curtailed arbitrarily, but must be controlled in a manner to ensure that the public's interest is protected when it comes to life and property. And also, the security and the protection of those who want to assemble is also guaranteed by the police by making sure that necessary deployment is done to protect and so ensure that their safety is guaranteed. So this is normal in a democracy.
But some members of the public, of course, the concern is that the police is part of the executive. Of course, it is out of goodwill to, to seek permit and be offered security. But there are some instances that the police would use that, of course, at the whims and caprices of the, the executive against the opposition, to exercise their fundamental right to freedom of assembly.
But that thinking goes against what has been obtaining in the past couple of years since President Barrow came to power. This Gambia police force has issued more permits to people to protest than Gambia has done since this law was passed. And most of this is given to, in fact, to the opposition. Recently, you saw the opposition came out, they want to protest against corruption, they were given a permit, and they marched until to the National Assembly. So, since President Barrow came to power, there has not been such an instance where the police willfully, out of whims and caprices, deprived people the permit, knowing fully well that giving them a permit would not cause any serious breaches of the security. So for that, we don't have an issue with that. The most important thing, a police must be notified of any protest or public assembly which borders on public safety and national security. The police must do an assessment of the situation and ensure two things. One, they provide the necessary deployment to ensure life and property are protected from the general public, people who have nothing to do with the protest, but also those protesting protagonists are also protected and their safety is guaranteed from counter-protesters. So the police should be a big, yes, there's freedom of assembly, but this must also be controlled in a manner which is in line with the public's interest.
We move on. We have a limited time. I'm being signaled right now. Another major concern expressed by some groups of people, but of course, who are also part of members of the public, is about the education, bit of it. The 2020 draft constitution guaranteed freedom of, guaranteed full access to basic and secondary education, free access to basic and secondary education. Some are surprised that in the drafted, constitution, that has been now limited to only basic education. Why the change?
Again, like I said, constitutions are supposed to be providing frameworks for governance. There are some rights. If you put them in a constitution, you put yourself in a serious situation. Now, if you know, as a country, as a government, a particular right cannot be guaranteed because of resource constraint, and you put that in a constitution, you open yourself for litigation. Now, if you put in a constitution that higher education should be free in the Gambia, but you don't have the wherewithal to provide that money, how much will it cost to say that secondary education is free? How much will it cost the government? Where will the money come from? And you cannot provide it. You open yourself for litigation. People can take everyday people are going to take the government to the courts to say that, well, the government is violating the constitution because the constitution promises and guarantees this particular freedom and the government is not doing it. So the government must be smart and understand what is possible in the foreseeable future.
But now we have freedom of, now we have free access to basic and secondary education. But has there been any instances that government has failed in that regard to an extent that people are, taking up litigative measures against the government?
No, but you remember, like I said, when we build a constitution, we don't think of what's happening today.
Yes.
We think of tomorrow. Gambia will come and usher in a society with a very strong civil society, with a very strong democratic community, with a very strong middle class that will take the government to court and hold the government to task. If we're not doing it today, doesn't mean that we'll not do it tomorrow. So government has to be smart and have foresight and be visionary to say that this could cause problems along the way. And now, even though it's not in the constitution, that doesn't mean that government cannot do it. It doesn't have to be in a constitution for the government not to do it. Right now, government is providing free education, basic and secondary, if I'm not mistaken. But it has to be, if you put it in the constitution, it means that it is incumbent, you must do it.
That is exactly what the constitution has done by saying that basic education is free.
Yes, it is free.
Now.
Yes.
But in the future, it could also be challenging for government.
Yeah, but government has done their calculations and know that one can be guaranteed. What cannot be guaranteed is secondary. And that which cannot be guaranteed can be put in the constitution, because otherwise you open yourself for litigation from the public. And you don't want a government to be always distracted by such litigations.
Thank you very much, the Honorable Minister. Viewers, those of you who are watching us, I've been talking to the Minister of Information on the redrafted constitution, which has also been gazetted by government and yet to be introduced to Parliament in some few months to come. Now we will move on, Honorable Minister, because we've got not much time here. Now let's go on decentralization of government. We have central and local governments. When you look at the 2020 draft constitution, has addressed the issues of decentralization of government. Both the 2020 and the drafted one have somewhat agreed on the need for decentralization. But there is one bit that is missing, that has been deleted from the 2020 draft. And that is section 206, subsection 3 of the 2020 draft, which has been removed, which is no person or authority shall interfere with or compromise a local government authority's exercise of its powers or ability or right to perform its functions under this constitution or act of the National Assembly. Why was it removed?
Look, I mean, it's like I said again, the CRC was haunted by Jammeh's ghost. I commend them. I think they did a fantastic job. But what obtains in Kenya and other countries, and I've seen that they've really drawn inspiration from the Kenyan constitution whilst we are drafting this constitution. Gambia is a centralized state. Decentralization is to ensure that government serves the public, serves the citizens at the decentralized level. And government cannot be everywhere. So therefore you need local governments to be able to provide some of the basic amenities to the people. However, decentralization doesn't mean usurpation. You cannot have micro-states within a state. You cannot have a state within a state. You cannot take powers away from the central government and give it to the local governance structures and say they should be working in a manner in which the central government has no say over the local government. That will cause anarchy in any polity. So therefore, I don't think it was a wise decision.
So the executive wants to interfere?
Not interfere. Not interfere.
So why was that section removed?
No. But what is interference? The executive must have control over the local governance structures.
Control.
Because they are here to serve the public. We can have only one sovereign authority in a state. Sovereignty cannot be, we don't have a federal system where sovereignty is shared between the center and the periphery. We have a centralized state system where the central state has the authority and the sovereignty to decide what happens in a particular territorial jurisdiction.
But devolution of powers is what we have seen in many democracies in the world.
We don't have devolution in Gambia. What we have is decentralization, where government gives some authority to local governments to do some particular job.
So it's a delegated responsibility?
Kind of. But it's not, we don't have a devolution like we have in the UK, where Scotland have their own devolved parliament, where Ireland have their own devolved parliament. We don't have a federal system like in Nigeria. We have a centralized state, a state that has absolute, unquestioned authority.
But that is not codified. That is not codified anywhere.
But it's in the constitution. Gambia is not a
centralized state.
Of course, Gambia is not a federal system. It's not a devolved system. Gambia is a central state. All power resides with the state. That is why the local governments cannot engage in foreign policy. They cannot have their own army. They cannot have their own police.
Powers of both the executive and the local
any power given to the local government authorities is given to them by the state, the central state, in exercise of its powers within the jurisdiction of the Gambian territory. So therefore, you cannot create a system where you say the local government must act separately. That is creating a state within a state, micro states within a state that can cause, that can precipitate anarchy in this country. So whereby you have a particular council saying, that we are going to act in our own way because we have our own powers. Then where is the state then? You cannot accept that in any country. No democratic country does that.
Yes. If you look at the 2020 draft and the revised draft, what is spelled out is that it shall be an object of the local government system that so far as possible, issues of local policy and administration shall be decided at local level, and the local government authorities shall cooperate with central government in adopting, a policy.
Exactly. So, cooperation. Cooperation is what is needed. They cannot be usurping the powers of the central state. They cannot be sovereign state within a state. That is not possible. So when you create a system like that, it causes problem. Like I said, if this 2020 draft of the CRC was allowed to pass in the first instance, it would have caused us a serious constitutional crisis in this country along the way.
But the draft says that both the central and the local government should adopt a policy of decentralization.
Of course, that policy should be put in place, and that's it's in the act. Mostly, it's in the act. The local government act will now define the relationship and the parameters of the powers of the local government, and also with its relationship with the central government. All these things are clearly spelled out in the local government act.
Yes, in the revised draft, in contrast with the 2020 draft, which requires the judiciary to submit its budget through the executive. The opposite was spelled out in the draft constitution. Because the judiciary is an independent institution, its budget has to go straight to the National Assembly instead of going through the executive. Why?
But who makes the budget? Who makes the budget? Who prepares the budget?
It's formulated by the executive.
Exactly. So the executive must be able to know whether a particular budget is sustainable or not. It's not to kind of derail any institution or to undermine the powers of any institution. But remember, the executive, like I said, is the one who makes and prepares the budget. So any budget that should go to the National Assembly is sometimes important for executive scrutiny.
Could that not be subject to abuse? Maybe the current government has goodwill, it was well-intentioned development, but we are making a constitution, for the future. Would it not be abused?
But who makes the decision for the budget? It's the National Assembly at the end of the day. Passing it through the executive doesn't mean that they make the decision. It's just that they want to have scrutiny over what budget is going to the National Assembly to see whether it's sustainable or not. Because the executive is responsible for getting the money from somewhere. They bring the money and they allocate the resources in confirmation with the National Assembly. So therefore, as you know, nothing wrong with, I think people are blowing these things out of proportion. I mean, it's good for it to go to the executive to see whether a particular budget is sustainable or not, and whether we can finance it or not, if it goes to the National Assembly.
The executive, of course, may not be happy with some decisions by the judiciary. Of course, we've seen some cases that have been brought before the court, and the court, of course, judgments coming out against the executive, but also against some members of the public. Who knows? Maybe in the future that could be subject to abuse.
No, I don't think so.
That is, of course, that's the argument.
I mean, this is best practice. A standard practice that the executive scrutinizes the budget of all the institutions in the country, because they're the ones who generate the resources and allocate the resources in line with what is sustainable. So therefore, nothing is wrong with that. I think people have to understand that.
Basically, everything will have to go to Parliament, and Parliament will have to...
No, of course, at the end of the day, it's not the executive that decides that votes on the budget. It goes to Parliament. Parliament is the one who makes the final decision.
But what goes to Parliament is what passed through the executive.
Exactly. So it has to pass through the executive. If
I needed $100, and I submitted it to you, and you find it unjustifiable or unreasonable.
If all other budgets, all other institutions, their budget go to cabinet before it goes to assembly, why should the judiciary not go to the executive?
Because it's an independent institution, and they wouldn't want the executive to interfere.
But you see, I don't think by routing it through the executive really is interference. It's for the purpose of scrutiny and to ensure that what they call budget sustainability.
Now let's move on. The CRC draft included a requirement for political parties to disclose their source of fundings during nominations. This requirement has been removed from the new draft. Why was it removed?
Well, this can be debated, but I think if the government is not financing political parties, they should have little say in how they get their finances, especially in our democratic setting. Some things will just cause problems. I mean, government doesn't give political parties any financing. So, I mean, this is something that is debatable. If it goes to parliament, political parties are represented there, let them debate it there. If they think that it's not good practice, they can decide. But based on my own understanding, is that in most countries where political parties are funded by the state, if political parties give you funding, now they can be able to scrutinize your income. But political parties don't get funding. And you want to know where they get the money from, and that can be problematic. How do you really, the nature in which we fund political parties are through crowdfunding, people giving particular donations. I mean, it's going to cause more problems than it's going to solve the problem. So for me, to be honest, let's debate this along the way and see what is.
That argument could be challenged. Mm-hmm. That let's say that is what is called asset declaration. Mm-hmm. Now, even though government does not give you the properties you own, you didn't get the properties from government. You work for it, you earn it. It was given to you, or you work for it. But you have to declare this to the IEC. If you want to work for the government, if you want to work for the government, you are contesting for public office, and you want to go, you want to work for government.
If you are contesting for public office and you win, you have to declare assets, isn't it? But in this case, it's a different thing. These are political parties that are registered as political parties. Yes, perhaps it's important for us to know their source of income, but should it be a matter of the constitution? That should be perhaps in the electoral laws, that political parties must declare their assets to the IEC. I don't think it should be an issue of the constitution again. Like I said, we're overflowing this constitution with issues that should be left to subsidiary laws.
Now let's move to the final question here. We've got no time. In just a few seconds, you explain this. The revised drafts specified asset declaration for the Vice President and ministers, and it did not include their spouses and children. But the 2020 draft did. But
are their spouses and their children employed by the state? I mean, that doesn't make sense. How can you force someone to declare their assets and you have not employed them? I am the one who is employed. I should declare my assets before I start office and when I'm about to leave. But why should I have to subject my family to an assets declaration when they're not employed by the state? So obviously, that should not even be an argument. That's a no-brainer.
Honorable Minister, thank you very much for coming to GRTS and explaining about government's position on the revised draft constitution. But I understand that this content is also simultaneously broadcast on some other national televisions. It's always a pleasure. Thank you very much for joining us, viewers. This was a special program, and I was joined by the Honorable Minister of Information, clarifying on some issues of concerns that the public raised on the revised 2020 constitution. Thank you very much for joining us. Until next time, bye-bye.